So, firstly, hello everyone, good afternoon, and welcome to this joint YMP Switzerland and YMP London webinar on mining disputes, a topic that is particularly pertinent at this time. This will be a unique webinar based on mining disputes, covering tax disputes, joint venture conflicts, and arbitration cases in the mining sector. This is a great opportunity to hear from top legal professionals, of which we're joined with many today, with extensive experience in mining law, arbitration, and dispute resolution. Before we get into all that, allow me to introduce myself. My name is Alex Christopher, and I sit on the YMP London committee and the Global YMP committee also. As a group, it is our aim to bring together young mining professionals in whatever sector in or related to mining that they work in. This event today, of course, is illegal in nature, but we will be hosting a number of events in 2025, so please look out on our LinkedIn pages or the website for updates. At YMP London, we had a great 2024, which included a mine tour, fireside chat, and C-suite mining with C-suite mining executives, and a pub quiz, as well as monthly sundowner events, amongst many other things. We look forward to building on that this year. And before I hand over to Diego, my counterpart at YMP Switzerland, I'd also like to mention the YMP Awards, a global initiative that we have within the YMP organization, which will be hosted on the Saturday immediately before the PDAC conference in Toronto next month at the Shangri-La Hotel. The winner of the Ira Thomas, the female award this year, is Anna Juarez, and the winner of the Peter Monk Award are the London Brothers this year as well. So if you'd like to attend, please do reach out. And with that, I'll pass to Diego for a quick introduction to YMP Switzerland and some housekeeping rules. Over to you, Diego.
Excellent. Thank you very much, Alex. As Alex said, I just take a moment to introduce YMP Switzerland and share a few updates on the upcoming activities. So now YMP Switzerland has been active for a few years now, and there's no surprise, Switzerland is a major mining ecosystem here. The country plays a major role in global mining industry. There are mining companies, Glencore, headquartered here. We have engineering firms, ABB, for instance, a strong network of investors. Some of them I can see the names are here today, and also a global trading hub with major commodity traders like Trafigura, Mercuria. Gold refineries, nearly 60% of the world's gold is refined here in Switzerland. There are NGOs on the responsible mining and gold supply chains. There are regulatory agencies related to the United Nations, and so on and so on. So at YMP Switzerland, we are trying to build the community here that connects all professionals from different aspects of the mining industry. And we have a lot of exciting events planned this year, like mine visits, fireside chats, as well webinars like this one. So please follow us on LinkedIn to stay updated. And also, if you are attending the PDAC in Toronto this March, feel free to reach out. We'll be happy to connect with you in person. Well, concerning housekeeping rules, all of you are muted right now. If you have a question, please use the webinar chat directly. I'm trying to answer to your questions. Now, I'm pleased to introduce Baptiste Rigaudeau. He is an experienced arbitration lawyer and an active member of Young Mining Professionals Switzerland, of the Executive Committee of YMP Switzerland. He's a partner at Lead Up Law, specializing in commercial and investor state arbitration. Over the past 14 years, he has worked and lived in Hong Kong, Houston, Madrid, Paris, Geneva, several places, and handling disputes in mining, banking, and energy as well. His role covers both counsel and arbitration duties, with experience under International Chamber of Commerce, the United Nations Commission on International Trade, etc., etc. So there are key frameworks in international arbitration. And beyond his legal practice at LeadUp, he plays also an active role in the arbitration community. He serves as the Swiss Arbitration Ambassador for France, is the co-chair of the Dispute Resolution Group at the American Society of International Law, and obviously a member of the Executive Committee of YMP Switzerland. He's deeply committed to promoting best practices, and we are super fortunate to have him as part of YMP Switzerland. The floor is yours, Baptiste.
Thank you, Diego. Can you hear me well? Can you confirm it's okay? Yes. Just thank you so much for the introduction. Just a quick correction. I'm not leading the dispute resolution group of the American Society of International Law, but rather the African Society of International Law. So thank you very much. We have, as you can see on your screen, we have three other distinguished speakers, which I have the pleasure to discuss with this afternoon, and which I'll introduce quickly. So first, Bianca Déprés, who is the General Counsel of Resolute Mining Limited. She has deep expertise in mining law, corporate governance, and dispute resolution, and she previously held a senior legal counsel role at Resolute, as well as being an associate in energy and natural resources at Princess Masons in London. And Bianca is an executive committee member of YMP London, and she's also been involved in Women in Mining UK. We also have Dr. Abdoul Karim Kabèlè Camara, who's the Vice President of Government and External Affairs for West Africa at Fortuna Mining. He's obviously a legal expert in mining and energy law, and he's held senior roles at Endeavour Mining and the African Development Bank. His expertise covers, as you'll hear, mineral taxation, corporate law, and stakeholder engagement in the ECOWAS region. And last but not least, we have one of my confrères in Mali, Mamadou Coulibaly, who is a partner at Satis Partners, specializing in mining taxation and corporate law in West Africa, with over 20 years of experience. And he has advised companies on tax structuring and compliance, and he's previously worked at Lane Christensen, Orange Mali, and Ernst & Young, former correspondence firm in Mali. So before we hear from them, I'll quickly introduce the topic of our webinar and give you a bit of a background as to why we chose that topic. So the reason is that, apart from the fact that I'm a disputes lawyer and I predominantly undertake dispute resolution work for private clients, we, as young mining professionals, we've also identified this topic as somewhat overlooked by our members, because we have mainly members which work in operations, in trading, geology, but not many lawyers. And so we thought there was a bit of a need for some learning here. And there's also obviously an increasing number of disputes in the mining industry. And because of the publicity of most mining projects, they are more and more known to the public and to other sector stakeholders. So again, there is a good opportunity here for clarifying what they mean and how do you deal with them. And given the current state of the world, talking specifically about tariffs and trade wars, there is an increasing chance that mining projects will again be subject to turbulences and potential disputes. But I'll come back on that aspect at the end of the webinar. So after some discussions with YMP members, we thought it would be useful to have a webinar on that aspect to shed some light on those disputes. And to start, we are actually going to take a step back and discuss first how to manage dispute risks for your company, for your mining company, through contracts and through foreign investment protection treaties. And so I have the great pleasure to leave the floor to Bianca Déprés first to answer the following question, which is: what can investors in the mining sector do to ensure that their investments are protected?
Thank you, Baptiste, for this introduction and just introducing the topic. I think that's actually very interesting. Just as a disclaimer, I'm not an arbitration or dispute lawyer by background, so I'm commercial. I'm head of legal, so I see a variety of cases and type of work. So I'll focus more on the commercial aspect of the discussion and a bit more practical in terms of from my experience and from what I've seen and what I would suggest to companies. So in terms of your questions on what can investors or mining companies do to protect their investment in a country, right? I think there's a variety of tools, but I'll just focus on investment treaties and mining convention, few clauses to keep just because of time. And then if we have to do a round 2 on this one, we'll do it at some point, right? So let's say investment treaty. We'll take a bilateral investment treaties which are entered into between states. I think the number one point to consider with a bilateral investment treaty is whether there's one available in the country you're operating. So let's say you're a UK-based company or Australian, and you have a mining company, a mining project in Senegal. Is there a bilateral investment treaty between Senegal and Australia, or between Senegal and the UK, for example? So that's kind of the number one point you would want to check. Number 2, I think the structure of the investment. So is that a direct investment, whether it's a company from the UK directly investing in Senegal, or is that from a shareholder? So you would have an indirect investment, and with that kind of treaty protection, with that bilateral investment treaty covers that, right? Second is the type of dispute that the bilateral investment treaty would cover. In some cases, you'll have BITs, so bilateral investment treaty, let's just call them BIT for the sake of this discussion, but in some cases, tax disputes are not covered. So you need to see if your dispute would fall into that category. I'd say also that the timing would be interesting in terms of structuring your investment. Would that be, would the investment be made, would the structuring, be made before you invest? Or let's say you're interested in making an investment after you're investing in a country. Would the structuring occurred after? So that's kind of interesting. The only aspect that you need to consider as well, among others, but I'll say this one, is that there's no dispute already with the state, or none that are foreseeable. So those are the key points, I think, for a bilateral investment treaty that say, if a bilateral investment treaty is not available, the other aspect would be a mining convention. So usually mining companies which invest in a country would enter into a mining convention, mining concession. So it's an agreement between the host state and the mining companies. And those are negotiated usually heavily. Sometimes there's a template that's imposed, but there are key terms that are essential for stabilization. So you would want to stabilize generally a fiscal regime. So the investors, so the mining companies, is protected against changes from the whole state tax regime, and which may impact the project or profitability, for example. And then in some cases, as I said, if a bilateral investment treaty is not available, in some cases, you would want to have your mining convention incorporating some of those clauses that you'd find in the investment treaty, right? So fair and equitable treatment. So you want to make sure the state is treating you in a manner that's fair, transparent, consistent, non-discriminatory, and it's in line with your legitimate expectation when you make the investment. Another one would be, and that's quite frequent, is the national treatment or most favored nation treatment, depending on the wording. But that's, again, it's to make sure that your host state treats your investment no less favorably than it treats its own national investors, or it treats investors from other states. So you're not penalized, you're against other states or against other investors. Another clause that would be relevant would be compensation for expropriation. So you want to make sure that the host states pays adequately or kind of an effective compensation, whether if the state interferes with an investment or projects. And then I would also add probably free transfer of funds as well, which is usually cited in bilateral investment treaty. So that allows companies to freely transfer funds, whether it's like profits, dividends, royalties, or any other payments that are related to the investment. And then I'd say as well, access to international arbitration. So you want to be able to bypass local courts in most jurisdictions, right? Depending on the local system. But I think most investors and most mining companies would want to have access to an impartial, independent tribunal that's usually not located in the host state, because generally if there's a dispute with the state, if there's a dispute in the project with the state, you wouldn't want to have any interference locally. So I think that covers quickly. I know we're short on time today because we do want to leave a time for Q&A at the end, but I'll leave that and then let me know, Baptiste, if you have like additional follow-up questions.
Thanks, Bianca. Actually, yes, I do have one follow-up question. And that's that you mentioned that a few key clauses should be part of a mining convention. Can you, so you mentioned a few of those, can you share any other ones that are helpful or that an investor should consider?
Yeah, that's a good question. I think another main one would be the material adverse clause that you would see just in case there's a changes in the regime, the system, how you manage your investment. So I think that's a one. And I think, again, I would just say, I'll come back to that, but the international arbitration, the right to proceeding, and to make sure that you have enforcement mechanisms as well. And generally, those would be relying on international protections.
I can only say that I 1000% agree with what you just said. So now that we know how to secure a private company's interest in the perspective of a dispute, we have to unfortunately discuss the situation where a company is in a dispute. And there are many types of disputes, as I said in the opening. So we've had to select some types that are more frequent. But to our audience, don't be sad. We'll do other webinars to discuss other types of dispute so that we are as exhaustive and relevant as possible. So in that context, we'll start with Mamadou Coulibaly for one type of disputes, which is always complex and tough to understand, but he'll shed light on those. And these are disputes relating to tax. So Mamadou, you have the floor for the next 10 minutes.
Okay, thank you, Baptiste. Can you hear me? Okay, perfect. Thank you. So I have to talk to you about the tax disputes and how to avoid tax disputes, or maybe how to reduce the impact of tax dispute and how to manage the tax dispute. What is interesting about the mining industry is it's really important to focus on the context. I mean, to take in consideration what is the context of the operation of of a specific company. What is important to note is that now, especially in Africa, since my experience is in Africa, the governments and the population have high expectations of the mining industry, and especially, you know, with this rising of nationalism and economic sovereignty. So the people and the states are waiting for more contribution from the mining industry. Also, another context which is also really important to understand where tax disputes can arise from is the fact that mining companies are often accused of being fraudulent with tax law, doing tax evasions or profit shifting. So there is a big focus of the tax office and the government on this operation. So what we can see based on our experience is that usually almost 100% of the cases finishes in tax reassessment. Anytime that a control is triggered, a tax control, tax audit is triggered against a mining company, it ends up a tax reassessment. So how to manage it, how to deal with it. So the best way forward the best way to deal with it in our tax practice is to reduce the risk. You cannot say for any type of company in the world, Google, Apple, anywhere in the world, any company cannot just state that we never had a tax reassessment. That's impossible. It's just like how you manage the risk, how you reduce the risk. So the ways we have, I will start by how to avoid or how to reduce the tax risk and the tax litigation in for a mining company, but it can be also applied to any other type of company. But specifically for mining companies, like Bianca was stating it, you have to check your environment, especially the mining conventions. But I will start by saying that you have to build a strong tax team and define some routines internally and externally through lawyers and tax advisors. So the first one is to have a good look of what is the environment of the said mining company. So mining conventions, stability clauses, it should be clear for that specific mining company what is the clauses and what are the mining tax, the mining code clauses applicable to the activity of the company. So which leads to having a clear tax or a clear overview of the tax regime of the said company. So then it's recommended to maintain a clear overview of the applicable taxes, especially by having a table with all the taxes which are supposed to be applicable to the said company. So whenever you have a mining convention and a stability clause, when you have a stability clause, it's just like the tax regime is frozen at a certain time. So that company, it's recommended for that company to draw up a table with all the applicable taxes. And also, one of the main topic or one of the main recommendation also is to update it anytime it's possible, but also to validate the way that this tax regime should be applicable. You know that almost 70% of the tax reassessments are based on misinterpretation. Misinterpretation from the tax offices, because sometimes when the mining convention was drafted, the tax office wasn't part of it. So sometimes they don't really understand what was the goal reach, or the goal that the parties were trying to reach. So what we usually do, or what we usually recommend to our client, is to have tax rulings, is to check with the tax office or the Ministry of Finance whether this is the proper tax regime, or whether this is the proper tax rate that we should apply to this specific tax, whether we are submitted to this tax or not, because you have the stability clauses, but sometimes you have new taxes. It's always good to have a clear answer from the tax office or from the tax from the Ministry of Finance to check whether new taxes are applicable to the company. Another way to avoid or to reduce, I mean, you see, I'm really insisting on reducing, because it's really difficult to avoid tax reassessment. In order to reduce the impact of the tax reassessment, is to have like a periodic tax review, internal tax review. Like the company should yearly have a tax review of its own operation and correct it whenever it's possible. So when it's not possible, the company should book some provision in order to mitigate, to reduce the impact of the tax reassessment. So also, that's also part of the context, but it's important to state that in our countries, tax inspectors receive incentive on their reassessment. So that, I'm coming back to it again, it's always difficult to say that a company can avoid a tax reassessment, since the inspector have to come with figures. So it's better to reduce that impact, to reduce the impact of these figures. That being said, when you have done everything to reduce the impact of what could be a tax reassessment and what could lead you to a tax dispute, a big one or a small one, is how to manage the tax dispute. The good thing is, usually tax disputes are clearly regulated, usually in the tax code. So you have to follow some patterns, and you have to to follow some processes. Depending on the jurisdiction, it can be smooth or it can be more aggressive. What is interesting in some jurisdiction, you can have directly a suspension of payment, because what you have, it's in the step, you have to respond first of all to the reassessment sent by the tax office. So it's not before a judge, but it's just between the company and the tax inspectors. So you have to provide proof or legal grounds to contest the reassessment. Then after you have the right to file an appeal before the higher authority within the state tax office. And depending on the jurisdiction, you can even take an appeal before the Ministry of Finance in order to escalate and to defend your position. So depending on the context, that can be solved smoothly or not, because depending on the jurisdiction, you are allowed to have a suspension of payment and execution. That's really important. When you have huge tax reassessment, in some jurisdiction, you can provide a tax guarantee. In some other jurisdiction, you can pay a part of the tax reassessment in order to stop the enforcement and allow you to discuss and to reduce the amount. So another step also, so what is interesting to note, especially we are talking about the mining industry, when we're talking about suspension of payment, legally you have the right when it's refused, because I can see that in some jurisdiction, even if it's provided by law, the tax office do not really answer to the request of the mining companies, just because they want to collect money quickly. You can, as a mining company, seize directly the judge in order to have a decision on the suspension of payment. But that specific process do not interfere with the right of the company to go before an international arbitration court, because sometimes, but not always, in tax disputes, the dispute can end up before an international arbitration court. Also, there are some things to consider based on the fact that, especially in Africa, where I have mostly my experience, sometimes you don't have a specific judge who knows what tax is, who knows how to deal with tax issues. So it may be interesting to go on some topics before international court, instead of just relying on the decision of local judges, because they don't really have the expertise. In some cases, we have seen that the judge asked to the tax office, despite it being a party, to provide advice on the case. So because they don't have knowledge on these questions. So just to finish on how to manage the tax dispute, usually when you are done with the hierarchy appeals, and if the case is not solved, what you see is like mining companies which have mining convention with an arbitration clause or possibility to lodge their case before an arbitration court. Usually they seize the arbitration court in order to deal with the dispute. But what we see in most of the cases, the government and the mining companies try to, they have a settlement. So it's a long process. It's not a matter of months. It can take time. But the good thing is sometimes you can see that mining companies, when they start lodging their claim before arbitration court, especially for dispute related to tax, they find a way to agree with the government. So that's roughly what I can say. I mean, if you have some follow-up questions or some discussions, I'm happy to answer to your questions.
Thank you very much, Mamadou. Do we have any questions from the panelists? Well, I do have one for you, Mamadou, and that's, you mentioned stability clauses, and you mentioned that some are general and others target specifically tax changes. what would be your advice if I am in a negotiation with the state for mining convention? Should I go for both the general and the tax stabilization clauses, or is the general stability clause enough?
So as Bianca has mentioned it earlier, mostly what you see is that you have a template of a mining convention. And also, it's really difficult to have a great enough space like to discuss stability clauses. We had a trend and things has changed. If you look at how the mining industry has evolved from these 30 last years, at the beginning for the oldest mining convention, you can see that the stability clauses were really general, covering the legal, the social, the economical, and the tax aspect. But with the development of the industry in Africa, especially I'm talking mostly about Africa, you can see that they are reduced the field of the taxability, the close stability clause. So it's not like you really have enough space to discuss which type of stability you want, but mostly it's stability clauses on tax provision. And also on that one, you can still have a lot of disputes around that one, because when you're talking about tax stability, sometimes government refers to the common tax regime, while the specific taxation on the mining industry is not under stability. So whenever they are changing the mining codes, they are also changing the mining taxes, which are not stabilized. So sometimes you can also have some dispute on these questions.
You should ask for stability of the whole mining legal environment, I guess, but that's probably a bit too optimistic.
Yeah, that's optimistic. Yeah.
Right. Oh, thank you very much, Mamadou. It was very helpful and complete. So,
Baptiste,
now
I think I would have like just emphasis. I think what Mamadou said about having a really good relationship with your advisor, I think that's key, right? Like Mamadou and I have worked together, and it's kind of building that really good relationship and foundation between the investors, the mining companies, and the local experts. And also, I think also another point that I think Mamadou raised, which was really interesting, and I wanted to highlight it, was understanding your mining convention, understanding the tax code, understanding local laws, but also regional law. So like we've seen it in West Africa when you have, for example, the HOADA kind of umbrella. So I think that's really interesting, and that's why like the local experts come into play. And I think I just wanted to emphasize that tax is quite a difficult beast sometimes to tackle. So that's why I think Mamadou's points were very good.
Thank you very much, Bianca. So turning now to Dr. Abdoul Karim Kabèlè Camara to discuss another type of disputes, which are joint venture disputes. And so we'll answer the questions: what are they? What is their concrete impact on mining operations? How do you avoid them? And of course, if you're in them, how do you manage them efficiently? Dr. Kabèlè Camara, you have the floor.
Thank you very much, Baptiste. First and foremost, I would like to thank the YMP London and Switzerland for the invitation to be part of this webinar. The topic and our discussion is joint venture dispute, the mining sector, but also other sector. But I think it's important to cover all type of joint venture, because the problem that you might have in one sector might be the same one that you have on other sectors. So it might be good to have it. Now I'm going to have to turn my thing in terms of my camera because of the internet to have a 100%. So what is a joint venture? As we all know, it's a strategic partnership between two or more companies that decide to pool their resources, their expertise, but also capital to achieve a common goal while remaining legally independent, right? And it is usually used in order to penetrate new market, but also share development costs, share risk, and exploit commercial opportunities together. Now, while all these type of the joint venture might offer many benefits, there is also a source of tension, and there are many causes to that, and that can impact the viability of the project, but also have an impact on the serious financial and legal consequences. So what are the main causes of dispute in joint venture? The first one, and very fundamental one, is the governance aspect and the decision-making process, right? From the onset, partners must agree on the decision-making procedure, the voting right, and respective role within the structure, right? Because generally the conflict between majority and minority partner can bring a lot of problem, especially if one partner holds a majority of a share and can impose his decision on the other party to the detriment of the other party. One of the examples is the case of Société Africaine des Matériaux versus Entreprise Générale du Bâtiment at the CCGI court. In that case, a minority partner challenged the management of the GV, claiming that decisions were taken unilaterally by the majority shareholder without prior consultation. So again, it is important from the onset that the rules need to be clear between all partners that are, or parties that are there, to make sure that there is no conflict between them. So for that dispute, the CCGIA reiterated the importance of complying with the article of the association and the shareholders' agreement to ensure balanced governance, right? If you take the case in Europe, for example, of Daimler and Chrysler in Germany in 1998 and 2007, Daimler and Chrysler has merged as a GV, but cultural and strategic difference between German and American management led to a governance crisis. So again, another aspect to take into consideration is the cultural differences, right? While you're writing your GV, you need to be very careful, not only to look at the strictly legal aspect of the convention, but also all the other aspects that are around. Another problem that we also face with GV is the non-compliance with contractual commitment, right? GV is generally based on a contract defining the obligation of the parties, particularly in terms of capital contribution, profit sharing, and participation in decision making. So conflict arises when one partner, for instance, does not honor his financial commitment, right? For instance, when you have a delay in investment, or there is a disagreement over the distribution of the profit or losses, right? We had that case as well with the CCGA, with Total, Gabon, and Perenco, right? Where you have two partners in the oil sector, but a dispute arose over the financing of the exploration, right? One might want to finance the exploration faster, while the other one wants to wait because they're trying to see how they can, get the funding that they need to progress in the operation. You also have the case of EDF and Veolia in France in 2003, right? Where a conflict broke out over the management of Dalkia, a GV in the energy sector. EDF and Veolia had opposing view on the expansion of the GV, which led to its restructuring. So these are all different cases that need to be taken into consideration. First, the governance aspect and the decision-making process. Second, the non-compliance with the contractual commitment. But also, they might have another aspect of the GV dispute, which is related to the conflict of interest and unfair competition. In certain situations, for instance, a partner may be tempted to favor its own interest to the detriment of the GV, right? And this case may result in first, misuse of the GV asset for personal gain, but also diversion of commercial opportunities and a breach of non-competition agreement, right? And you have this situation again in the OWADA sector, but this time with the Société Minière du Katanga and a local partner. That also was a case that was brought before the CCGA. It's an OWADA court with all the disputes related to commercial activities and so on. So the local partner exploited the deposit outside the framework of the GV, right? All this to say that there are various reasons why a GV should be run smoothly, but unfortunately, partners that are into the GV can have different perspective on how this GV can be run. And there are numerous cases. If you case the Bolloré case with the Cameroonian partner, you also have BP and Rosneft. At the end of the day, it is important in order to prevent this conflict to draw a clear and detailed shareholders agreement, right? I think that's the basis. When you enter into an agreement with someone, you need to draw up a clear and detailed shareholder agreement. Specify exit and conflict resolution procedure to be sure that if dispute arise, there is a proper way of dealing with it, right? You have the mediation and the conciliation, arbitration, whether it is at ICC or CCGR or OWADA. And like Mamadou and Bianca said, to avoid court, state court, because sometimes they don't have the expertise. But I think now on we have institutions on the continent, such as the African Legal Support Facility, helping government negotiate complex commercial transactions, helping them to be able to train, whether they are judges or lawyers, to make sure that they are able to help. So, you know, there is a need for an effective management of the GV dispute. Is essential to preserve the business relationship. You know, GV disputes are common. They are not new, and they are in all sectors, not only the mining sector, but with good governance and solid contractual framework, they can be avoided, right? Arbitration and mediation are the best way of avoiding lengthy cost proceeding. And sometimes you don't want people to be biased towards one party, so it's always preferable to go to international courts. So it is also essential to plan exit and conflict mechanism from the outset of the GV so that we avoid any type of problem. Thank you very much for your listening. And if there is any question, I'm happy to answer that.
Thank you, Abdoul Karim. I have one question, which is which has had an impact on one of my cases, and I would like your view on that. And that's, how do you ensure that the employees of the JV or the local employees that are involved in the running of the JV stay loyal to the JV instead of favoring one partner to the other, and especially when there is a dispute looming or actually materialized, so that then you can use them as reliable witnesses, for example, in the arbitration process.
Yes, look, it's always difficult, you know, because it depends. It's people, right? It's depend on how you treat them, right? Because if you bring someone into a GV, even if you are the one who brought the guy on the GV, if you don't treat them right, when there is a dispute, they might lean towards the person who treat them right. So my answer will be, first one is to treat people right. Make sure that everybody abide by the rules, by the book, right? And more importantly, by the contract that's being signed, because that's an employment, you know, employer and employee contract or relationship. We make sure that everybody has a clear and know exactly what his role on the GV, what he's supposed to do. Generally, if you take, for example, a mining, you know, an exploration company, where you know that, you know, the objective is to make sure that you get to the development of the project and then building of the project. You make sure that people know that if the company succeed in his exploration, then they will go into production and everybody will be happy, right? Not only the investor, not only the owner of the mining company, but also the employee. But again, it is important, right, to make sure from the onset, you know, you have good governance. If you have good governance in your company, then you will be able to have that check and balance that makes sure that, you know, even if you are majority shareholder, you don't take decision without taking into consideration the minority shareholder, right? And there is also a way of having the golden rules, right? Even if you are a minority shareholder, there is always a way to get back to you and to have some information. I hope I answered your question.
Yeah. Thank you very much. It's a very difficult question, so I appreciate that you had to answer it on the spot. So now, after these presentations and by popular demand, for the next 5 to 10 minutes, I was asked to say a few words about the impact of tariffs, trade wars, and there are some that are looming, looking at the US, for example. So the impact of those trade wars on mining projects and what types of disputes can arise from such events. So as we all know, trade and tariffs wars are not a new phenomenon. They have impacted operations before, and they will again, unfortunately. Trade wars also have an impact on the price of minerals on the market, which in turn means an imbalance in contracts where the price of commodities may have been agreed between the parties in relation to a formula, taking into account price fluctuations on markets and other factors. So these types of disputes, which are frequent in times of trade wars, are called pricing disputes, and they can generally be resolved via negotiations, amicable settlement, for example, mediation, which I was happy Abdoul Karim was mentioning, and these amicable settlement will result generally in a new price being defined. The parties can't agree on a new price of commodities, then they will have to go back to their contract and see what dispute resolution mechanism is provided for. Generally, at least in my experience, for large supply contracts, it's arbitration. You can also have disputes in supply chains, which are impacted by the prices of materials rising because of trade wars. Performance of a contract from one side, for example, performance, for example, of a farmer agreement in a mine can become more onerous because of the cost of material and because that cost becomes too high. Generally, in those instances, it will be difficult to invoke force majeure because, among others, one of the conditions of requirements of force majeure is that performance becomes impossible. And in those instances, it's not that performance becomes impossible, but it just becomes more onerous, it costs more. So depending on the agreement in question, for these disputes relating to supply chains, this can mean seeking an agreement from the other side that economic conditions in the contract be renegotiated. Then that agreement, that type of agreement can mean a temporary easing of some of the financial contributions to be paid by the party operating the mine or to which the operation has been farmed out. For all supply chain types of disputes, it's important to document any change in economic circumstances of the contract and to seek an amicable solution with contractual partners when possible. You should also provide in a relevant contract for a renegotiation mechanism or clauses that allow parties to take into account changes in economic circumstances to ensure the appropriate allocation of risks. And last but not least, trade wars may also mean more tax measures imposed on foreign investors in retaliation by states. So states that are the victim of an increase of tariffs on their goods will generally try to retaliate on foreign investors through tax measures. Those tax measures, as alluded to by Mamadou, can be challenged before foreign investment tribunals if the foreign investor is from a state which has signed a foreign investment protection treaty with the state enforcing punitive taxes in retaliation. And as Bianca rightly mentioned too, if tax measures are not excluded from the realm of the said foreign investment protection treaty. So that's a quick overview of the type of disputes that can arise in those trade wars, tariff wars contexts. And time will tell if those disputes will materialize, but I can already tell you that we may do another webinar specifically on that topic. So now that we are almost to the end of our webinar, we now come to questions and answers time. And we have a question. And yes, the speakers should put their cameras on if they can. We have a question, which is an interesting one, and I think it's directed to Mamadou. And that is from Alex, who says, if a manufacturer of EV battery components wants to bring the production facility from China to Africa, are there tax holidays? I'm assuming it means tax implications? I don't know if Mamadou, you can answer that question, or at least give general comments on what sort of tax implications there are with bringing a production facility into Africa in countries you have experience in.
So I think the question is related to tax holidays or tax incentives,
right?
Because that's the main focus of investors. I mean, when they are moving a facility or moving a plant, they want to know what will be the cost of that reallocation. So depending on the jurisdiction, so what is interesting to note is, for example, in West Africa, you have a competition between countries, and all the countries in West Africa have their own investment code. So, and this investment code are deemed to attract investment, foreign investment. So, and the main topic, I mean, what is pursued in this investment code is the creation of value, creation of local value or added value. So as long as that facility brings more employment, more transfer of know-how locally, and increase local production and exportation, then there will be some tax holidays on tax incentives based also on the level of the investment. So depending on the jurisdiction, depending on the area, you can have interesting tax holidays.
Okay, thank you. Thank you very much. There is a question from Luke Harrison from London, boutique Caden Harrison. And he says, do the panelists think that there are any particular arbitration institutions that work best for mining disputes, excluding investor states? So maybe I'll let the panelists answer if they do have a view, and then I'll chime in with my own view. Bianca, do you have a preference?
Look, I don't think there is a particular country that is better than the other one, right? Because at the end of the day, arbitration can be held everywhere. The most important thing is to have the good arbitrators and the good venues as well, right? Some country you goes, we have national arbitration center, but they are not well equipped, right? If you want people to come to your arbitration center, you need to show some type of seriousness on the way you handle the cases and how the procedure is being conducted. So for me, I think there is not a specific countries or whatever, but the most important thing, because you go to arbitration because you want people dealing with the case to be expert in the case and know exactly what they talk about. That's why most of the time people prefer to go to arbitration rather than going to state court, because they are scared of corruption or the court being biased towards the state or something like that. At the end of the day, like I said, it's a matter of the professional that you have and that dealing with your case. Thank you.
Yeah, I think I fully agree with Abdoul, and I would also add, I think another important mechanism is the enforcement, right? Once you have an arbitration, you come to a conclusion, and let's say the mining company's the investor wins, there's an award that's granted, then how can you enforce it, right? Like, is the arbitration tribunal referring to mechanisms such as the New York Convention, for example, where actually they can do a tracing of assets from a state that's usually outside their own countries and then seize. So those are, I think, the mechanism that you would want to look for as well.
Mamadou?
To be sure, I think in the question is that the auditor is asking whether which is the best institution, excluding investor state. So I think he is referring about cases where there's an investor against a state. But just on that one, because it's not part of the question, but I think it's interesting to talk about that, is the best way forward, especially with African countries, is the exit, because it's related or linked to the World Bank. And when we come to enforcement, like Bianca was saying, that can help also, because the World Bank have some leverage against the local governments in order to have an enforcement or easier enforcement of the awards.
Yes, yes, I agree. So from experience, I've had mining related disputes in many types of institutions, sorry. ICC, LCA, Corsica, which is the Cairo Center, in Egypt, and ad hoc. And I would certainly advise private parties to choose international institutions in their dispute resolution clauses. It's tempting sometimes to agree to a dispute resolution clause which refers to a local institution because you do want the contract to be signed, but that can really be a problem, and that goes also to what you were saying, Bianca, is enforcement. Because if you've got an award which is the conclusion of a process which doesn't abide by international justice standards that would be enforced in international arbitration institutions and by international arbitration tribunal, that can be a problem at the enforcement stage. And of course, as you were rightly mentioning too, I mean, the key is to have the right arbitrator, right? Somebody who's done mining arbitration or has some sort of interest in mining, because there's so many elements that go into a mining operation. You need to have that in mind. And certainly, as far as investor-state arbitration is concerned, you rightly pointed out, Mamadou, that ICSID is obviously the preferred means of resolving investment disputes. Although it's not the only one. You can also do investor-state arbitration ad hoc, and you can even do investor-state arbitration with international commercial arbitration institutions like the ACC, for example. And that brings me to my last point, which is when you are tasked with choosing the right institution, it can also be that you want to make sure you don't pay too much for you don't overpay, sorry, for the resolution of your dispute, and the way arbitration costs are calculated between those different institutions is also a point that can play a part in your choice. Some of those institutions having their remuneration calculated on the amount of disputes rather than, and others are rather on an hourly rate basis. So that can also be an element to factor in. I hope my panelists don't disagree. So I think it was our last question, unless there are other questions.
But it's one thing I wanted to say is that, you know, there are some countries now, such as Rwanda, that are setting up an arbitration center. As you can see in the region, there is a new paradigm shift across the region, right? Like I said, for me, the most important is to how do you make sure that when you have an award, you enforce it, but also having the right arbitrators, right? Because, you know, we choose arbitration because we want people that gonna hear the case, that they know what they're talking about and they know the technicalities of what we're doing. So in that sense, you know, it can happen anywhere, even in Africa, right? And then it can be done right if you have the right venue and the right people around. Now I know that for state and investor arbitration, you have all these international organizations. Of course, you have the World Bank and the IMF as a Damocles sword in the head of the state. So it's easy for investors to go there because they know that they will be protected. But this is based on the fact that sometimes there are a lot of uncertainty in the way people are dealing with investors sometimes, right? You find situation where, tax clauses can be changed, although there are, stabilization clauses that are there. Now, the question being, with gold price rising up, can we still keep the same provision that were in some contract, while you have now the ounce go to 2,900 an ounce. So from the government perspective, it might be a case for them to say, well, look, the price is up. Why do you think of giving us a bit more of that share as well? Which is fair for us, for the company to also bring the case and to explain why, because there are operation costs and many things that that needs to be taken into consideration. Thank you.
Yes, and that's why it was also important to mention that resolution of a dispute doesn't always have to be confrontational; it can also be amicable. Taking into account the whole context of the contractual relationship. Great. So if there are not other comments from the panel, I don't see any additional question. I'm going to conclude by saying three things. The first one is that I really deeply thank our speakers, Mamadou, Bianca, Abdoul, Karim, for their participation. I know they're all very busy professionals, and so it's really a pleasure for me to have had the luxury of talking to them today. And I also deeply thank our YMP Switzerland and YMP London organizational gurus for making this webinar happen. It's been hard work, but it's great to have a co-event finally happening. And let the number of participants today be testament to the appetite for co-events like this. The second point is that, again, you should follow our LinkedIn accounts, the Switzerland and the London one, to keep up to date with our next events, YMP events. And the third point, which is dear to my heart, is that if you've got suggestions for events, or topics you would like to be dealt with in the type of format we've just had, a webinar, then let us know by email or LinkedIn, and we'll try to make it happen as we did today. On that note, unless anybody has additional points to raise, I will wish everybody a nice afternoon.
Thank you very much, Baptiste. It was a pleasure taking part of in the webinar, and always a pleasure to join again if there is any other one.
Thank you so much, Abdoul, Karim, Bianca, Mamadou, Diego,
Thanks,
and Alex.
Mamadou. Thanks, Bianca. It was a pleasure.
No.
Same here. Bye.
Bye.